least you can know me. That's number one. Number two is that I have a very short period to start to teach you this semester. Somehow, maybe second semester will be better, but I have just a short time. So I want to make it, memorable. So we are here today. We continue with the burden and standard of proof, which is the only topic I'm going to teach, this semester. But on Friday, I will come with, we will do the remaining part of the class. If whatever leads to, then I try to take 2 or 3, bring 2 or 3 past questions, create scenarios, talk to it, and also allow you people to talk. With that, I know you are okay with my own side of this semester's lecture. And the area that I'm teaching, or the area that the topic that I've been given this semester, is a little bit, anyway, what I have done is to make sure that I have, I'm going to give you the note on, my glasses is not that clear. Do we have anybody with tissue or something so that I can clean it? So maybe on Wednesday or Thursday, I will send my notes, your own notes, to the class rep. If I can work on it tomorrow, if not, before Friday, you should have it so that you can look at it. If you have questions to ask me, then if you have questions, on the note, if you have past questions, we can just look at it and work on it together. So that's basically what we'll be doing on Friday. I will give you this outline, or is it a little bit of, you can call it handout, notes, so that you will understand what we have been teaching, very well. Because the cases are long. And the reason why I've reported it like that is for you to be able to appreciate, the principle. So we started with burden of proof, and we said that burden of proof is the burden of proving, of establishing facts, the task of establishing facts. And when we talk about evidence before, evidence is about what? Establishing, facts. So we looked at the burden, the task of establishing facts, the meaning of burden of proof. Then I think that, what else? The burden of proof. We looked at burden of proof in civil cases, looking at section 132 and 133 of the Evidence Act. And we said that the burden of proof is what? Is on the person that asserts, but at times, even within a case, there may be some positive assertion from a particular person, and that person must establish those facts. So I said that today we are going to look at burden of proof in civil cases and criminal cases. Last week we looked at burden of proof in civil cases. We continue with burden of proof in criminal cases. And you know that in Nigeria, we practice the adversarial system of government. And one of the tenets is that there is what? Presumption of innocence. And because there's presumption of innocence, the prosecutor must prove the case beyond reasonable doubt. Let's open to section 36(5) of the Constitution. You may not have it, but I have it here. Section 36, subsection 5 of the 1999 Constitution says that every person who is charged with a criminal offense, every person who is charged with a criminal offense shall be presumed to be innocent until he or she is proven guilty. So proof is what? Everybody is innocent. If you have been charged with a criminal offense, You are innocent until you are able to establish, the prosecutor is able to establish your guilt. So we also have section 135, subsection 1 and 2 of the Evidence Act. Section 131, section 135 and 2 says that if the commission of the crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be what? Proved beyond reasonable doubt. And verse 2, I say verse 2. Subsection 2, sorry. Subsection 2 says that the burden of proving that any person has been guilty of a crime or wrongful act is subject to 139 on the person who asserts. So it's the prosecutor that will come to court and say, when something happened, maybe a murder has occurred, the people around that area, or maybe the parties involved, they will go and report at the police station. It's the police that will prepare the charge sheet. That maybe they will try and arrest, the people involved. They will draw the charge sheet, and they will say, that you, Mr. A, on so and so date, on so and so place, you killed one Mr. Mustafa. So, is the police, or you have committed the offense of murder contrary to section so of the criminal code. So they are the ones that will go and investigate. And when they get to court, they've done their investigation. You have ingredients of murder. There must be, intention to kill or cause grievous bodily harm. When did it occur, So those ingredients, they will prove it in court. So in Obasanjo Egereba versus the state, Unguwata GSC stated that the meaning of proof beyond reasonable doubt. Just listen and get the explanation. I'm going to give you everything because I understand that this topic is, so I'm going to give you everything. You can read the case, you can understand it, so that whatever comes out of it, you'll be able to, do justice to it. So it's not a topic that I can just teach you anyhow. It's a topic that I have to report cases for so that you can understand the principles very well. So we are looking at burden of proof in criminal cases. And I spoke about the Constitution of Nigeria that says that there is presumption of innocence. Then the Evidence Act says that if the case is a criminal one, then the burden of proof will be what? Beyond reasonable doubt. So we are trying to look at the meaning. What is beyond reasonable doubt? I'm sure you have been hearing of beyond reasonable doubt. So Unguwata GSC stated that beyond reasonable doubt is looking at a case, Gay Copper Regime versus State, is cited in that case, that the Supreme Court of India said that a reasonable doubt does not mean some light, airy, insubstantial doubt that may flip through the minds of any of us or about anything. It does not mean a doubt begotten by sympathy or out of reluctance to convict. It means a real doubt founded upon reason. Is the fact that that the court will be able to say that you have proved it beyond reasonable doubt. It's not like it's a concussion. It's not like there should be sympathy, but it is based on reason. It is based on fact. And in Nwataruocha versus the state, we get it here. In Nwataruocha versus the state, Rose Bible noted that proof beyond reasonable doubt does not mean proof beyond all doubt or all shadow of doubt. It simply means establishing the guilt of the accused with compelling and conclusive evidence. So when we are talking about beyond reasonable doubt, just try to establish the guilt of the accused. Bring substantial evidence that the court will say, oh, it has been established that the accused did this. So that's the meaning of beyond reasonable doubt, that we'll be able to establish the guilt of the accused. There will be compelling evidence to establish the guilt of the accused. And look at this case of Simeon Ajogu versus the state. Everything is here. So in Simeon Ajogu and the state, what happened was that the appellant was arraigned with 3 others for offenses of conspiracy and kidnapping. According to the Court of Appeal, it is tried that in all criminal trials, that the burden of proof is constantly on the prosecutor, and it is proved beyond reasonable doubt that for you to prove the offense of kidnapping, you see the ingredients. You must show that the victim was seized or taken away by the accused, number 1. Second, that the victim was taken away against her consent. Number 2, that the victim was taken away without lawful excuse. So those are the ingredients of what? Kidnapping. The victim was seized, was taken without her consent or his consent, was taken without lawful. So you must be able to establish those ingredients before you can say that you are proving the offense of kidnapping, before you can say that it is proved beyond reasonable doubt. So the second and third ingredients are not an issue. That is, that the victim was taken away against her consent, that the victim was taken away. Those were not an issue. What was an issue? The cross of the appeal resolves around the first ingredient, whether it was the appellant who kidnapped the victim against her. Was it the appellant? So the other 2 ingredients, they've been able to establish that it was against her consent and it was unlawful. But the first one, was it the victim that seized, was it the appellant that seized the victim? One of the ingredients. And the court looked at it and said that according to the court, it is only material contradiction that can It is only material contradiction that can affect prosecution's case. Contradiction, how the appellant was mentioned by the victim when she said Simeon, Emeka, Okuku, and Charlotte abducted her, and the son told the court, PWT told them that she was abducted by the first to the fourth accused. Court said it was clear on record that the appellant was the first accused person, and his name was Simeon. She said Simeon, she mentioned their name. The first appellant was Simeon. Whether he is called the first accused person or Simeon, both refer to the appellant. The next contradiction is the number of days the victim was held by the kidnapper. The ingredient of the offense did not require a particular period of day, whether you kidnap the person for 2 months or 2 hours. Was the person seized without a consent or his consent? Was he the first appellant? Was he part of them? So the ingredient of the offense, yes, the identity of the appellant is the central issue in the appeal. The victim, PWT, told the court that at the point of kidnap, she was made to sit on a motorbicycle. As they were going, they fell down, and both herself and the rider got burnt from the exhaust. And that was the point she was blindfolded. So she saw the rider of the bike. She told the court that when they got to the forest, the blindfold was removed, and she recognized the appellant and called his name. She said it was the appellant who used her phone to call her relative for ransom. Even if there is a discrepancy as to the date of the identification parade, there is adequate evidence to link the appellant with the offense. He was the one who had a burn from the motorbike exhaust. The victim identified him, called him his name, and recognized his voice. Hence, there is no material contradiction. Hence, there is evidence linking the appellant to the kidnapping, which is what the law requires and has been established. The appeal was dismissed. So there is proof. The 3 ingredients of the offense were established. And that was why the appeal was dismissed. I'm trying to explain proof beyond reasonable doubt now. So you could see in that kidnapping case that 3 ingredients. Was it the appellant? Was it against the victim consent? Was it unlawful? And we could see that it was unlawful, and that the victim did not consent. So later they were able to establish that it was the appellant, whether they called his name Simeon or anything. And they even saw some things. The exhaust pipe that burnt them, he also had the mark. So what we are trying to say, there has been proof beyond reasonable doubt because the prosecutor has been able to establish the ingredients of the offense. So let's go to Section 139 of the Evidence Act. So Section 139 of the Evidence Act is talking, evidence. We always have exceptions. So proof beyond reasonable doubt is for the what? Prosecutor. But at times, if you as the accused person, if you have some facts within your knowledge, then you have to present those facts. And that's what Section 139 is saying. Burden of proof in criminal cases. Where a person is accused of any offense, the burden of proving the existence of circumstances bringing it within an exemption is on him. So we know that normally burden of proof is what? Is beyond reasonable doubt and is on the prosecutor. But if you as the accused person, if you have some particular facts within your knowledge that you want to use, you too can always adduce that evidence. And the one we are always talking about, one of the exceptions is what? Insanity. There is a presumption that everybody is sane. So if you want to say you are insane, then you have to adduce evidence. I think another exception is alibi. I think I have to verify, but I know about insanity very well. And the Evidence Act mentioned insanity in Section 139, subsection 3C. So the defendant will prove the defense of intoxication and prove the defense of insanity or any exception that he has to prove it himself. So in this case of Nigeria Air Force versus Kamaldeen, Nigeria Air Force versus Kamaldeen. So we have looked at Section 135 that talks about proof beyond reasonable doubt. We have tried to look at the meaning of beyond reasonable doubt, looking at Ajoku and the state. Now, we are talking, Section 139 is talking about where there is an exception or exemption that the accused himself wants to prove. It's not the prosecutor that will prove your exemption. You are the one. That exemption is within your knowledge, and you have to prove it. And that was what happened in Nigerian Air Force and Kamaldeen, Section 139. This is an appeal against the decision of the Court of Appeal Lagos, where the Court of Appeal set aside the decision of the General Court Martial, where the respondent, Squadron Kamaldeen, was arraigned before the General Court Martial on 11 counts. He was found guilty of 10 counts, sentenced to 35 years imprisonment, and another to pay over 2 million. This was in 2007 as compensation. Dissatisfied, he appealed to the Court of Appeal. The Court of Appeal set aside his conviction and discharging. Nigerian Air Force now appealed to the Supreme Court. The Supreme Court, it was a case of the fact that he took some money without authorization. The Supreme Court said that, held that it is settled law that where a person is accused of any offense, the burden of proving the existence of circumstances bringing the case within any exception or exemption is on him. In the instant case, huge amount of money was taken, or is it were taken? Huge amount of money was taken from the Nigerian Air Force, and the money was shared among the officers who participated in the withdrawal. If they had the authority to do so, the burden is on them to prove authorization. Especially because they withdrew the money and they shared it, not that they used it for any lawful purpose. So the burden to prove the authorization that this money that we withdrew, that we had authorization, was on them. It's not for the prosecutor to be proving it beyond reasonable doubt. It is very instructive in the instant case that the respondent admitted that one of the purposes of the money was to bribe the staff of CBN. The court further held that it was not the case of the Nigerian Air Force that the outgoing chief of air staff authorized or refused to authorize the withdrawal of the money. The case of the appellant was that the respondent and his other colleagues conspired and stole the money and shared. So it was the respondent who asserted that they were authorized, and therefore they have to prove the authorization. So the Supreme Court held that the General Court Martial was right to have found them guilty and to have found them guilty of the offense. So the crux of the matter in this case was that you took money. So, of course, it is left for the prosecution to prove the case beyond reasonable doubt. But you are saying that this money that you took, you had authorization for it. That was the defense. So if there was authorization bringing you under an exception that, okay, that was the reason why you took the money, then prove it. And because they could not prove it, they were held guilty by the General Court Martial, and the Supreme Court said that they were guilty of the offense. So that is standard of proof in criminal cases and Section 139, where you have exemption. Do we have any question? Okay, the reason why it's an exception is that if you look at, is it 37? I can't even remember by heart. If you look at it, there is a presumption that everybody is safe. So a murder has happened, and you now want to raise the defense of insanity that, okay, Mr. A killed Mr. B because he was insane. So it's not the court that will prove that you are insane. You are the one that will raise that defense of insanity. So when the prosecutor is saying that, so Mr. B has been killed, you as Mr. A will now raise the defense of insanity. So it's not the prosecutor. The prosecutor will just raise the fact of murder. You will now raise the defense of insanity. So it's a defense. You now raise the defense of insanity. So that's why it's an exception. So it doesn't need to say, this person has been killed, this. Once you raise the defense of insanity, then you establish the things that, whether it's insane delusion, you establish the ingredients of the defense of insanity. In fact, call medical evidence and the way the person has been behaving, the community will come and testify. So many things. Yes, any other question? Okay, so let's go on. We have said that the topic is what? Burden of proof and standard of proof. So we've looked at burden of proof in civil cases, which is that is the person that asserts that must prove. Burden of proof in criminal cases, which is on the prosecutor, which he must prove beyond reasonable doubt. Then we are not talking about standard of proof. What is the standard of proof? Standard of proof is the quality of proof that you want to bring to court. In other words, this is a minimum or baseline standard that the law, statute, or otherwise has placed on both parties. So when we say standard of proof, the minimum standard that the law or statute has placed on the parties that you have to bring to discharge your burden. The degree or level of proof demanded in specific cases. In criminal cases, it is beyond reasonable doubt. In civil cases, it is on the preponderance of evidence, on the scale of evidence. So when we are talking about standard of proof, what is the, standard has to do with quality. What is the quality of proof that you are even bringing to court? So there is also a difference between standard of proof in civil cases and standard of proof in criminal cases. So what is the quality of proof that you are bringing to court? You cannot just go to court now and said, somebody stole your money. The court will look at it. Okay, by the time you even get to the police, the questions they'll be asking, okay, write your statement. So they will look at the statement. Is the statement that we allow them to even draw the charge sheet? If you are saying that they stole your money and you can't establish whether there was a taking or there was a conversion, you can't establish the ingredient of stealing, then you cannot say that your money has been stolen. You understand? You want to establish a burglary, that your house has been burgled. Is it in the daytime? Is it in the nighttime? Was anything? So, as you are making your stories at the police station, they'll be asking you, as you are making your statements, they will say, okay, write it well, write it well. Because when they are preparing the charge sheets, of course, they must have done their investigation, trying to establish the ingredients of that particular offense. So the ingredient is very, very important. If the ingredient is not there, then what is the quality of evidence that you are bringing before the courts? Like I told them, in the gender class today, that you want to establish the offense of rape, and you are just telling stories. The court will look at it and see, was there octus reus? Was there penetration? They will look at it. Was there consent or lack of consent? They will look at it. Is there anything to corroborate whatever you are saying? So what I'm trying to say is that there is always quality of evidence. You can't just come out, because in Nigeria is what? The adversarial system. So it must be proved beyond reasonable doubt. That is in criminal cases. Even in civil cases, you don't want to go and waste the time of the court that we enter into a contractual agreement, and then he has taken I supplied 100 bags of cement and he did not give me money. The first thing the court will look at is the contract. Let's look at the terms of the contract. Was there an offer? Was there an acceptance? Was there consideration? Was there intention to create legal relation? They will also look at, the court will look at the documents that you have exchanged. They will look at, was there anything, that showed that there was, you supplied. Was there any invoice at the other end, saying delivery notes that they collected? So all these documents, they are trying to do what? To establish. But let's say that you've gone to court that Mr. A is owing me 1 million naira. I supplied 100 bags of cement, and you didn't adduce any documentary evidence to that fact. Everything was just story. So the court will always look at the quality of the evidence, and the quality of the evidence will be tailored towards law, what the law is saying. So that is standard of proof. Then standard of proof in civil proceedings. In civil proceedings, we have section 134 of the Evidence Act. It says that the burden of proof shall be established on the balance of probabilities in civil proceedings. And what is balance of probability? In Mogaji and Odofin, the Supreme Court said that the totality of the evidence should be considered in order to determine which has weight and which has no weight at all. Therefore, in deciding whether a certain set of facts given in evidence by one party in a civil case before a court in which both parties appear is preferable to another set of facts given in evidence by the other party, the trial judge, after a summary of all the facts, must put the two sets of facts on an imaginary scale. So the plaintiff has adduced evidence. I supplied 100 bags of cement. Everything is 1 million naira. This is the delivery note. This is the agreement. The court will put it on an imaginary scale. The defense that is denying, no, they did not even submit. I did not even know him before. They too, they will adduce their evidence. The court will put it on the second scale. You know the scale of justice. So the court will now weigh it. Which one is the most credible evidence? Accept it in preference and then apply the appropriate law. Which one is the most credible out of this evidence? Is it the person that has been able to bring out all original documents and the person that is just saying no, no, no? Which one is the most credible evidence? This is precisely why the totality of evidence must be considered and why a trial judge must weigh the conflicting evidence adduced by both parties and then draw his own conclusions. So that is the what? The balance of probability or preponderance of evidence, putting the evidence of each party on different scales, on this one on one scale, the other one on one scale, and weighing it to see the one that is more credible. In Toti and Ukwabi, the Supreme Court held that the standard of proof in civil case remains constant in the sense that the standard of proof is based on balance of probabilities because we don't want to injure the litigant more than that. So it's always on the balance of probability. In Anoike and Anoike, the court said that section 135 and 137 apply to civil cases, and they provide that the person who has alleged the existence or affirmation of a fact must adduce it, must assert it, must prove it on a balance of probability or preponderance of. We are still explaining the same thing. It's just for you to understand that in mortgage, there is always, the court is always having an imaginary scale and putting evidence of A party on one and evidence of B party on one and on the other, and looking at the one that is more credible. So in Alhaji Ndalu Esu versus Alhaji Sani Baba Nkachi is here. I'm going to give you. So what happened in that case was that the case of the plaintiff appellant at the court below is that they own the land in dispute, which was a gift from the Esunukwe at that time to their progenitor, you know, giving oral history. You know, that was how they got the land. Malam Ibrahim alleged, you know, that they got the land because of something that they did, that the appellant grandfather appointed the sixth appellant grandfather, you know, to take care of the land. They traced the history of how the land evolved on them. They went on, that went on until they found out that the respondent had acquired different interests in the land. So they now brought the respondent to court. So that is their own case. So that is one evidence that, okay, this land, they traced it from one generation to the other, how that land became their own. Then the case of the defendant respondent was that the land is part of the land covering the northern and eastern part of Bida, founded by one Etsu Zaki, the progenitor of one of the ruling houses in Bida. that it was later sold and they became the owner. They gave their own story. So the Court of Appeal held that the burden rests on the party who asserts a thing and whose case will fail if it does not establish the case on a balance of probability. The burden is on the appellant they are the one that's saying, tracing their history about the land. They are the plaintiff, they are the one that went to court, who made the assertion as owners of the land in dispute to prove indeed that they are entitled to their claim. According to the court, proof of an assertion or claim in civil matter is not beyond reasonable doubt, but based on preponderance of evidence. The portion of the appellant's story of their grandfather progenitor killing a deer was not successfully discredited by the respondent, and whether or not it was sufficiently established should be considered along with generality of evidence. So the evidence that the appellant, the plaintiff adduced, the respondents were not able to counter it. The evidence remains that the family is part of the Umaru Majigi ruling house. Therefore, the inheritance of the land in dispute from their progenitor grandfather was not far-fetched and is credible. They properly gave the identity of the land a claim with the survey plan, Exhibit A, and the site of the land in dispute was confirmed by some witnesses of even the respondent about the certainty of the portion in land. The appellant had proved their claim and entitled to their land. Appeal succeed. So you could see the evidence that they adduced about how their great-grandfather got the land, how they killed the deer, how they were given the land, the survey that was done, that even some of the respondents, some of their own witnesses even attested to it, that the land was certain, the portion was certain. So the court put that evidence on one side. They put the one of the respondent on the other side and said, no, these are the owners of the land. So in civil cases, it's not as straightforward as that. At times, you may have a civil case, and then you have some criminality coming out of it. So what Section 135, subsection 1 says is that if a civil case is going on, and then you have some facts which are criminal, that area, that portion will be what? Proved beyond reasonable doubt. So that was what the court, that's the position in the Evidence Act. If in the course of a civil case is going on, maybe it's about trespass to land, and in the course of it, somebody was killed, maybe all this Omonile, the person now used force to enter the land, that this land, though, I will not, and fight ensued and was killed. Something has happened now. Somebody has died on that land. So there is what? A murder case. So prove that murder area, that fact, will be what? Prove beyond reasonable doubt. Or maybe they started fighting and somebody was stabbed, assault occurred. That aspect of it will be what? Prove beyond reasonable doubt. So I just reported this case so that you understand what I'm saying. Among Hiri and Emate Were, you will see it here. So that, because when you don't, if I'm just mentioning the principles and you don't see cases, it's very difficult to understand. So in this case, now it's a civil case. The plaintiff had alleged trespass to his land and destruction of his crop planted. He further alleged that he once reported the matter to the police. After investigation, the police refused to take action on the ground that it's a civil matter. In fact, it's in the Administration of Criminal Justice Act that the police, if you go and report a civil case to the police, they should not handle it. So at the trial, the plaintiff tendered some statement made to the police over the matter, which was admitted as Exhibit C and D. So it was the defendant's contention now that the entirety of the plaintiff's case more or less involved a great deal of criminal allegation. Hence, it must be proved beyond reasonable doubt, because he has gone to report to the police that so his case, what is the cause of the case? Is it not trespass to land? But because he went to report, the defendant are now saying, no, is a criminal matter and it must be proved beyond reasonable doubt. In dismissing the argument, the Supreme Court held that where in a civil claim, a party can succeed without proving criminal motive, then it should go ahead. Section 135 will not apply. The mere fact that he advanced that he reported the matter to the police did not turn it into a criminal case, and that in any case, the police even refused to treat the matter and say it's a what? It's a civil case. So the mere fact that somebody has gone to report a matter to the police will not make it a criminal case that you will not be saying it must be proved beyond reasonable doubt. It depends on the cause of action, the content. What is it about? Is it a contract? Is it a land matter? Is it a divorce matter? So if it's not a criminal matter, you can't be contending that it must be proved beyond reasonable doubt. And because of this, what has happened is that in election cases, over the years, election is a sui generis, is a peculiar petition that you have taken to court. But because of some of the issues that we always arise, you have criminal things there. If you have snatched ballot boxes, if people are fighting, all these things, they are what? Criminal activities. So people will always go to court. And generally, election is on what? It should be a civil case, which should be on what? Preponderance of evidence. But by the time they take all these criminal allegations there, then what will happen? They can use that one, they can be on the case forever because they are still proven beyond reasonable doubt. So what the courts normally do is to do what? To severe and see whether we can remove the criminal allegation from the civil, matter. And that is what they have been doing over the years, even though it has been resolved now. In Aregbesola, Rauf Aregbesola and Olagunsoye Oyinlola is a 2010 case. The appeal is against the judgment of the Governorship and Legislative Election Tribunal. The facts of the case are that on the 14th of April 2007, the fourth respondent, INEC, conducted an election for the office of the governor of Osun State. At the end of the election, the fourth respondent announced that the first respondent, that is Olagunsoye Oyinlola, scored a total of 426,000 votes as against that of the petitioner, and declared the first respondent duly elected and returned as the governor of Osun State. So he was declared as the governor. Dissatisfied, the petitioner filed a petition before the tribunal and said that votes were not recorded in 10 local governments. There were malpractices, violence, which affected the validity of the election, that the said Prince Olagunsoye Oyinlola was not duly elected. He didn't get the majority vote. The tribunal held that the petition in relation to the local government borders on crime. So the main allegation are intimidation, scaling of votes, party agents, and thuggery, ballot stuffing, ballot snatching, and non-announcement of results. So the court said that all these ones are what? Criminal offense. So the issue for the Court of Appeal was whether the tribunal was right in its decision by concluding that all the allegations by the petitioner appellant related to criminal offenses and that it must be proved beyond reasonable doubt. So, should it be proved beyond reasonable doubt? According to the Court of Appeal, the petitioner appellant said that no votes were recorded in any electoral form as having been scored by each candidate at any of the polling stations by any presiding officer. The presiding officers in all the said polling unit did not at all material time describe the polling results. there was no counting and announcement of results, specifically in relation to, the respondent, especially the first to third respondent, argued that all the petitions were criminal in nature. According to the Court of Appeal, Section 28 and 64 of the Electoral Act 2006 said that counting and announcement of results at the polling units and collation centers are matters which are in compliance with the provisions. The said Section 28 and 64 of the Electoral Act relate to procedure at election. It follows that allegations touching on non-counting and non-announcement of results touched on non-compliance with election, and it is civil in nature. So what the court did was that they used what we call severance. So the Court of Appeal held that they used severance to remove whatever is criminal from civil. And looking at civil, non-counting of votes and so on and so forth, they still held that the respondent won the election because they did what? They used severance. They removed whatever criminal and look at the civil aspect of it, non-counting of votes and so on and so forth. That's what they have been doing. It has happened in Omobori Owo and Ajashin. The court used the doctrine of severance to look at it and say it's criminal, it's a civil case. But this has been settled by Section 135(3) of the Evidence Act now. There was a recent amendment, and Section 135(3) has stated that in election matters, whether the commission of crime is an issue or not, proof will be on what? Preponderance of evidence or balance of probabilities. So there is no need to remove to severe or anything now. Once it's an election petition, the proof is what? Or preponderance of evidence or that is, they are going to put the evidence of petitioner A here and petitioner B here and look at the more credible evidence. The court is not going to look at whether it's civil or criminal in nature. So that is the new addition to the Evidence Act, so that election petition will not go on forever. So we continue with this class on Friday, and then we take our questions. I'll make sure you have this on latest by Thursday so that you can read it and you can ask me questions. So good afternoon.
Thank you very much.
Oh, okay. Use your phone. Okay.